Okay, let's continue. Video 6, obligations of tenure, which we'll start learning about incidents. The incidents owed for a tenure accepted would be compared to being taxed for the use of land today, called property and real estate taxes, which is all currently owed to a system of government. Now, today we no longer see the obligation imposed for the right to be secured against all the world according to the legal title to property we hold, as we have basically learned, under the misinterpreted definition of ownership, or where an enjoyment of property, not as a legal title owner in season, but as a tenant in possession, who are both equally representative through the rules of action that secure their different interests to the same type of interest. So we're talking landlord and tenant agreement. Now, as a note, the English common law looked to the individual who had possession before it looked to the individual who held season. And the one who held possession was the one who was immediate advocate, or the one who was immediately liable for the obligation. And so that is the party that the law would look to first in order to settle a matter or dispute. Now, also today, we just use secondary legislation that sets boundaries according to the interest being determined. So you as a citizen are holding a third level use to land, where government has a second. So they create secondary legislation in order to manage or administrate over those interests properly. Now, this will become more apparent as we learn what law is, which is basically comprehending that English law's fundamental nature is to advance the evolution of laws that become interpreted as the value of security against the type of interest held as a tenant, which is then annexed to a status. And everything, if you're a tenant, previous to being a tenant, there has to be a land interest. Property tax, I would only surmise, including a whole host of other taxes, is the equivalent of fulfilling an obligation within the feudal land tenure system today. Citizens most definitely are those who were at times of yore, were those who, everything ended up to the individual who's responsible for working the land. Okay, so who's the laborer? That is how the entire system that we have seen prior to those seized in service and those seized in domain. The same thing applies to citizens are the ones that are seized in domain interests, and they are the workers of the land. When's the last time you see government actually do anything except maybe pick up a shovel just to break some ground or use some scissors to cut a ribbon? Paying money in lieu of service. So now we start looking at how taxation started coming involved, where money is used instead of service. Paying money in lieu of service, so a per battle tax per se, was later used to fulfill the obligation of a specific tenure called scutage, in which this type of incident had its beginnings in the feudal land tenure, when lords did not want to join a crusade to suit up sometimes for a warmongering king who's always at war and is always asking for your service. And also at the beginning, if a king began to over-exercise his prerogative right of rule through either not having definitive laws in place to protect the knights, like, hey, there's no knight union here to speak on our behalf, or if the king just simply ignored the laws, and some events such as the signing of the Magna Carta of AD 1215 occurred when the king was, pushing his weight around too much, his prerogative too much, and not amending to the agreements that were in place between the knights and the kings. Now, what traditionally at the time, if you were a knight, you had to serve 40 days of knight service, and which you were compelled to serve the king to lend your sword and shield. Now, but mainly to fulfill the requirements of the tenure he accepted. So again, if you're under military service, that's a tenure accepted. Well, then obviously you have to be compelled to 40 days service throughout a year. Now, also keeping in mind, we have to look at service at that time. In Britain being an island, everything was generally overseas. So you could see probably, overreaches of those 40 days had occurred. Either A, not having the actual people or the actual knights available to take over a fight that was, continue on, or a campaign that was continuing on, or maybe there was logistically, after a certain period of time, the king hasn't returned, the army's returned, then they've sent over a whole new set of knights over and to relieve the knights that were already in service. I'm not really sure, but you can see that, 40 days were probably just the minimum, and there's many times that it extended, or there was more than one fight that was occurring throughout the year. Now, knight service was not an invention of the Normans. Obviously we have the Romans and so forth. It's also common to the Anglo-Saxon culture, the German culture, that they had, a type of knight service. And also under the tribal structure, we had those that needed to defend the tribe or defend the chieftain. Now, incidents defined immediately following the conquest involved, as Borlaska writes in subsection 22 of chapter 1 of his book, Cases and Notes on Land Law. He states, the control of wardship and marriage, and these are incidents, the control of wardship and marriage defines on alienation and requirements of attornment, the Lord's duties of warranty and defense, and the ceremonial practices of homage and fealty, unquote. So those will be defined as the types of incidents. Now, we don't need to really explore each one of those things. I may sometime, along the English law series, but I don't really feel it's necessary. I can touch maybe just on worship and marriage. Like taxes are to government, so is to a lord having the rights of wardship and marriage. And wardship is just generally having the rights of who is going to be the next individual that's taken over the land if his immediate lord or someone died or is no longer there, and so he wanted control of who's taking over that land. Obviously didn't want Pee Wee Herman there to take it over and say, oh yeah, well, that worship or that tenure was for knight service, and you got to strap on the your father's knight armor. Now, so he wanted that control, as well as control of that land also meant that he could, under wardship, let's say if the knight perished and the heir, through generally primogeniture, which is the first male heir, was yet of age, he could be able to fit somebody in that position until, that child was of age in order to be considered taking over that tenure. But there's also death taxes. In fact, most all incidents are all death taxes. So when somebody immediately dies, the heir had to take care of either those interests, which were sometimes 1 year of value of that land was to pay in lieu of the death. Sometimes it's percentage, or it could be primercision, which was, hey, I take over the land myself, control it, and I get all of the interest. So there was a lot of different things in worship. And you can see why it was imperative for the Lord to have that interest so he can control who his tenant would be, or have a still value given to him at the incident that the one that was in charge prior had perished. And we look at marriage. Marriage was so you can control families. And we can see that now. That's a lot of the whole engravement, even the royalty. It's all about who's breeding with who in order to gain a little bit more control. And that's the same with any of the tenants in chief and the mean lords and so forth, that they had to control the interest. And sometimes some property manors were shared by two different tenants in chief. They overlapped. So if you wanted to take control of that, and you being maybe having the larger tract, maybe you had more control, you would say, okay, I want to control who marries that heir, so that I am then assured that either we're not going to feud against each other, so we'll get some sort of marriage agreement so that we both have a common interest in that same property that's not going to create a feud, or that, again, you want your heir to marry someone else that you want to align with, and you would then choose that marriage. So you've heard it many times, seen it on different movies and stuff, played over and over. Now what we want to take simply from this whole right to land under English law tenure system is that all property held today is subject to an obligation. And that's the point, as we mentioned, the difference between the contrast between the Roman civil law, the French use, and the English law. The French essentially just remove the obligation. And I've got a whole bunch of paper on that. And that paper will help you better understanding through the contrast of using Roman against English law. And with every English law, with every property right or estate and land, there is an obligation attached. That is just a proponent of English law. Now, thanks for being with me. I will thinking of visiting Blackstone commentaries next, and we will tap into the prerogative of the king. So we'll get an understanding who the king is and such. And don't remember to spank that like button or don't like whatever. And I've been guilty of myself, listen to a video, enjoy the video, and after I ended, I go, oh, geez, I didn't, say I liked it. So here's your reminder. And subscribe if you haven't done so. Thank you for listening, and we'll see you next on video 7.